Not even the Supreme Court can order the Director of Public Prosecution. Can anybody challenge the decision of the Director of Public Prosecution to withdraw a matter he took to court? This now has been settled. Kenyans created Article 157 and insulated it with a security of tenure. The Director of Public Prosecution serves for a tenure of 8 years, non-renewable. It's a constitutional office, and he cannot be directed as provided for Article 159, Article 157.10. So anybody challenging the decision to withdraw a case, the law provides for under Article 87, no, Section 87A of the Criminal Procedure Code. The DPP can withdraw any matter at any time before judgment. Welcome to Court Helicopter Explainer. Here we are dealing with the criminal law. Under the criminal law, there is an office called the Office of the Director of Public Prosecution. Under Article 157, this is an independent office. It was not there under the old constitution. Under the old constitution, the Department of the Director of Public Prosecution was a department under the Attorney General's office. The prosecutors were police officers. They could arrest, they could investigate, they could take you to court, and the police prosecute. Under the Kenyan Constitution, that mandate moved to an independent office called the Office of the Director of Public Prosecution. There has been a lot of noise that the Director of Public Prosecution is withdrawing cases. There has been a lot of noise that the weakest link to the fight against corruption is the Office of the Director of Public Prosecution. There has been the question, how does the director exercise his powers? The police and the Director of Public Prosecution. Can you compel the Director of Public Prosecution to charge somebody? Can you go to court and tell the Director of Public Prosecution, there's an advocate called Stanley Kinyanjui, I want him arrested, and you charge him? Can Vivian, aggrieved and mad with another journalist, go and compel the Director of Public Prosecution to charge that person? This was the question that arose in a case that has gone up to the Supreme Court. A Pakistani journalist who was a thorn in the flesh of the politics of Pakistan came to Kenya in hiding. He was murdered in Kajiado County. The police accepted it was a mistake. They shot him accidentally. This is the first time the police are accepting that they shot him accidentally. They were wheeling thugs. They were waiting for a certain car. The Pakistani car passed, and the police officers, who are GSU officers, thought that this is the car. They flagged it down. It didn't stop. They shot the Pakistani journalist dead. Investigation started. And when the investigation started, the file went to the ODPP. The ODPP said there is no sufficient evidence to charge the police officers. Aggrieved, the family went to the Constitutional Court of the High Court, asking for compensation and also an order to compel the Director of Public Prosecution to charge. The High Court agreed that a violation of fundamental human rights was occasioned and awarded her 10 million. The High Court did not compel the Director of Public Prosecution to charge. Aggrieved, the wife went to the High Court of Appeal. The Court of Appeal did not give her what she wanted. She appeared before the Supreme Court. The Supreme Court agreed with the High Court that there was a violation and still did not enhance the 10 million shillings she was given as compensation. The Supreme Court retained 10 million shillings as compensation. But the question about whether the court can compel the Director of Public Prosecution to charge somebody is what we are dealing with. What is the issue? In page 35, the judges framed this issue, whether this court can compel the DPP to prosecute the police officers responsible for the fatal shooting of the deceased. That is the question that was before the court. And the judges looked at Article 157(10). The Constitution provides that the Director of Public Prosecution shall not require the consent of any person or authority for the commencement of criminal proceedings, and in the exercise of his or her powers or functions shall not be under the direction or control of any person or authority. So in section 69, the judges are saying the constitutional insulation of the Director of Public Prosecution against control or direction in the exercise of his or her powers in terms of when and whether to commence criminal proceedings is unequivocal. Therefore, there appears to be little or no room for maneuver to circumvent this independence. Now hear what the Supreme Court says. Not even the Supreme Court can order the Director of Public Prosecution. Not even the Supreme Court can order the Director of Public Prosecution. That is the finding of the court. And the judges said, the answer to this issue before us is therefore that this court cannot compel or direct the DPP to institute criminal proceedings against the police officers responsible for the fatal shooting of the deceased. This is a decision by the judges, Justice P.M. Mwilu, Deputy Chief Justice and Vice President of the Supreme Court, Justice S.C. Wanjala, Justice of the Supreme Court, Justice Njokindungu, Justice of the Supreme Court, Justice Lenaola, Justice of the Supreme Court, and Justice W. Oko, Justice of the Supreme Court. This is a judgment of 3rd day of July 2026. What is the import of this matter? It is now settled. Nobody can control the office, the Director of Public Prosecution. The President cannot control or direct the Director of Public Prosecution. The public cannot direct the Director of Public Prosecution. No court of law can order the Director of Public Prosecution to charge. It is his discretion. If for now that office, nobody can force it. So then the next question, can anybody challenge the decision of the Director of Public Prosecution to withdraw a matter he took to court? This now has been settled. Kenyans created Article 157 and insulated it with a security of tenure. The Director of Public Prosecution serves for a tenure of 8 years, non-renewable. It's a constitutional office, and he cannot be directed as provided for Article 159, Article 157.10. So anybody challenging the decision to withdraw a case, the law provides for under Article 87, no, Section 87A of the Criminal Procedure Code. The DPP can withdraw any matter at any time before judgment. The Supreme Court has confirmed that. Anybody attacking the DPP should now understand that at that office, nobody can direct it, not even the Supreme Court. Wakili Danstan Omari, putting it as it is, I know it will not be very palatable. The EACC must have read this. They now understand that the power to prosecute is absolute in the office of the Director of Public Prosecution. No any other entity can prosecute. No any other entity can sign a charge sheet. And no any other entity can take the role of the DPP, and no any entity in this country can order, can direct the DPP to do that. Wakili Danstan Omari, a pleasure.